Welcome to Registrar Corp's webinar today, Regulation Makeover, How MoCRA Will Transform the Cosmetic Industry. At Registrar Corp, we proudly offer importers, exporters, and regulatory professionals a comprehensive array of services and software that help companies achieve and maintain FDA regulatory compliance. We understand how daunting FDA compliance can be. Our team of qualified experts provide the support you need to help keep your supply chain compliant and protect consumers, your brand, and reduce the risk of costly disruptions to your business. I am Jacqueline Belomo, the Director of Cosmetic Services and Software at Registrar Corp. I support the team on regulatory guidance and requirements for cosmetics, as well as providing support on our Cosmetry Product Manager and GMP software. I am joined today by Anna Benavente, the Director of Product Labeling and Ingredient Review at Registrar Corp. She manages a team of regulatory specialists who review and revise product labeling to bring it into compliance with US FDA requirements. Thank you to all our participants joining us today. We look forward to providing you with important information necessary to understand MoCRA and its requirements. If you have any questions throughout the webinar, please write them in the Q&A box and we will address them at the end of our presentation. We will be sending out a recording of this presentation to you all within the next few days. Here's our agenda for the next hour. We will first be covering a brief roadmap of how U.S. cosmetic regulations started, where regulations have been the last 20 years, and how that has led us to MoCRA. We will also discuss two significant updates about VCRP and the reorganization of the Office of Cosmetics and Color. We will then outline MoCRA's top 10, which are the most significant changes that will require action as early as this year. Our What's Next will go into detail about timing for these requirements, including when we expect to see proposed and final rulemaking, and also take you through some initial steps on how to prepare in the coming months. Lastly, we will take some time to answer some questions. As early as 1930, consumer protection groups and journalists started pushing for new and improved laws due to the overwhelming adverse events seen in the drug, food, and cosmetic industry. The FD&C Act of 1938 gave FDA authority to oversee and regulate the production, sale, and distribution of food, drugs, medical devices, and cosmetics. Under this act, cosmetics did not need FDA approval before distribution in the US and only prohibited the marketing of adulterated or misbranded cosmetics. The changes and adaptations have been made, such as the Color Additives Amendment in 1960, the Fair Packaging and Label Act in 1966, and the Cosmetic Ingredient Review Expert Panel in 1976, the regulations still lacked the visibility and testing to ensure product in the hands of Americans were in fact safe. Until MoCRA, a cosmetic product listing was a voluntary program through FDA and required existing sales in the US to be able to qualify. This meant that the cosmetic product was already being marketed in the US with no prior verification or government authority review. Over a decade of lobbying for reform left many US states creating their own regulations to govern what ingredients were allowed to be used in cosmetic products. California, a leader in reforming regulations, enacted Prop 65 and continues to ban ingredients and update the requirements to protect not only cosmetic consumers, but the environment as well. Other states such as New York, Colorado, Washington, and Vermont started to regulate cosmetics as well, banning PFASs, microbeads, and microplastics. These state regulations started to demonstrate the need for MoCRA and also awaken the beauty industry to start listening and asking more questions about what went into their products. In the early 1990s, many trade association, product consumer councils, and independent organizations started to form during this time and created the trade associations representing cosmetics and the personal care product companies and serving as the voice on scientific, regulatory, legislative, and international issues for the beauty industry. These trade associations started to advocate for impact to bring to the forefront the lack of regulations around cosmetic and personal care products sold in the United States. While other industries such as food and drug had several new laws and regulations put into place, cosmetics was still left behind with minimal updates. In an attempt to prevent issues seen in the drug manufacturing side, FDA issued a guidance for the industry entitled Cosmetic Good Manufacturing Practices in 1997, which since has been revised in 2008 and again in 2013. The latest revision of this guidance, FDA has incorporated elements of ISO 22716, which is the European standard required for cosmetic good manufacturing practices. The next 8 or so years, beauty consumers, multinationals, and brands continue to educate the industry about cosmetics, their safety, and ingredients while pushing for reform. MoCRA is the first major overhaul in U.S. cosmetic regulations in 84 years and has put into place major provisions that have safety and transparency at its forefront. Under MoCRA, FDA creates new standards and requirements which we will review today in more detail. In some shocking news, FDA announced that the voluntary cosmetic registration program would no longer be accessible for new submissions as of March 27, 2023. All submissions made after the enactment of MoCRA have not been processed by FDA and will not be processed. FDA is working on a brand new software solution to submit facility registrations and product listings. The systems for registrations and listings will go live at the same time. Data from VCRP will not be migrated over to the new system. All registrations and product listings will need to be done regardless of whether they were entered into VCRP previously. The data currently in VCRP will be archived by FDA, but companies will not be allowed to alter this data moving forward. Another significant update is the reorganization of the Office of Cosmetics and Colors. The Office of Cosmetics and Colors is currently under the Center for Food Safety and Applied Nutrition. The Office of Cosmetics and Colors will move to the FDA Office of the Chief Scientist, which sits within the FDA Office of the Commissioner. FDA's Chief Scientist, Dr. Bumpus, will be leading MoCRA's implementation. FDA has launched a dedicated MoCRA website to support the industry during the rulemaking process. FDA is also reorganizing the Center for Food Safety and Applied Nutrition and other human food-related offices into the new Humans Food Program. The office will closely collaborate with FDA's Human Food Program, Center for Drug Evaluation and Research, Office for Minority Health and Health Equity, and Office of Women's Health.
Thank you, Jacqueline, for that wonderful introduction for our webinar. As Jacqueline mentioned, cosmetics regulation was not very robust until the passage of MoCRA. Now we'll dive into the requirements imposed by MoCRA and how your firms can begin to prepare to come into compliance by its deadlines. MoCRA introduces some new terminology to cosmetic regulation, so it's important to understand how MoCRA defines specific terms so that you can determine which requirements will apply to you and your products. There are 4 key definitions of which you should be aware: responsible person, facility, safe cosmetic, and serious adverse event. MoCRA introduces the concept of the responsible person to cosmetic products and their labeling. The term responsible person means the manufacturer, packer, or distributor of a cosmetic product whose name appears on the label of such cosmetic product in accordance with Section 609A of the FD&C Act or Section 4A of the Fair Packaging and Labeling Act. MoCRA states that the responsible person is charged with conducting certain activities related to the product listing, adverse events related to the product, substantiation of safety for the product, additional labeling requirements imposed by MoCRA, and fragrance allergen disclosures and records. We will discuss these requirements in greater detail later in our presentation. MoCRA also introduces the term facility, with respect to cosmetic firms and products with a very specific definition. The term facility includes any establishment, including an establishment of an importer, that manufactures or processes cosmetic products distributed in the United States. A facility will be responsible for facility registration and GMP compliance requirements issued by FDA. There are exclusions and exemptions to some facilities that need registration. We will also discuss these requirements in greater detail later in our presentation. Firms should determine whether they fall under this definition, as it has a significant impact on which activities they must conduct.
MoCRA defines the term safe. The term safe means the cosmetic product and its ingredients are not injurious to its users under the conditions of use prescribed in the labeling or when used in a customary or usual manner. FDA will not consider a cosmetic ingredient or product injurious to users solely because it can cause minor or transient reactions or minor or short-term skin irritations in some users. MoCRA defines the term serious adverse event. It means an adverse event that results in or requires medical intervention to prevent death or life-threatening experience, an infection or inpatient hospitalization, a persistent or significant disability or incapacity, a congenital anomaly or birth defect, or significant disfigurement other than as attended under conditions of use that are customary or usual, such as serious persistent rashes or infections, second or third degree burns, significant hair loss, or persistent or significant alteration of appearance.
Now that we have a fundamental understanding of the key MoCRA definitions necessary to understand how and to whom the requirements will apply, we will move into Registrar Corp's MoCRA Top 10 Things to Know about the new impending regulations. The first new requirement that must be addressed by many firms is the mandatory cosmetic facility registration. Prior to the passage of MoCRA, there was no mandatory registration for any cosmetic firm, only the voluntary program in which firms could elect to participate after their goods were on the market. As noted earlier in this webinar, that program has been discontinued. MoCRA mandates registration for owners and operators of facilities that manufacture or process cosmetic products for U.S. distribution. Existing facilities will have 1 year from the date of enactment, which was December 29, 2022, to register their facility with FDA. New facilities that manufacture or process cosmetic products for distribution in the U.S. must register within 60 days of marketing the product or 60 days after the deadline for existing facilities, whichever is later. Companies must notify FDA within 60 days of changes to their registration information, and FDA registrations are now renewed every other year. Foreign companies must designate a U.S. agent as part of the registration. FDA is expected to establish an abbreviated renewal process for firms that have not updated their information since the last registration. MoCRA also introduces a new requirement for cosmetic product listing to be completed by the responsible person, the manufacturer, packer, or distributor named on a product label. The listing must be updated annually. Similar to the facility registration process, FDA is expected to establish an abbreviated renewal process for any listing to which there has been no change since the responsible person submitted the previous listing. MoCRA also offers flexible listings, a single listing submission for cosmetic products that have identical formulations or formulations that differ only with respect to colors, fragrances, or flavors, or quantity of contents. This is why it is important to review the new definitions established by MoCRA to determine the requirements that will apply to your firm. For example, a contract manufacturer who is not named on the label would be required to register as a facility, but would not do a product listing. A distributor named on the label would do the product listing, but would not meet the definition of facility and therefore would not register. A manufacturer who is also named on the label would do both facility registration and product listing. FDA has firmly established cosmetic labeling regulations in the U.S. Code of Federal Regulations that must be followed in order for products to be in compliance. MoCRA adds new labeling requirements related to serious adverse event reporting contact information, fragrance allergen declarations, and a specific statement for professional use products. Product labels will need to declare a domestic U.S. address, domestic U.S. phone number, or electronic contact information through which the responsible person can receive adverse event reports from consumers. This may be through a website. In addition, cosmetic products that contain certain fragrance allergens must list them on the label. FDA will publish a list of allergens that are subject to this requirement in the future. For professional cosmetic products, labels must indicate a clear and prominent statement that the product is to be administered or used only by licensed professionals and is in conformity with existing cosmetic labeling requirements. While mandatory for other categories of products that FDA regulates, until MoCRA was passed, there was no adverse event reporting requirement for cosmetic products. Now, MoCRA mandates that the responsible person named on the label must submit a report of any serious adverse event that it receives from a consumer along with a copy of the label. MoCRA also broadens the scope of what constitutes a serious adverse event to account for factors specific to cosmetic products. Serious adverse events include those that result in or require medical intervention to prevent death, birth defects, infection, disfigurement, disability, or other significant negative effects, such as hair loss, permanent or persistent alteration of the appearance, or burns. MoCRA imposes significant record-keeping requirements on responsible persons, particularly for adverse events. Records of adverse event reports must be maintained for 6 years, and FDA must be able to access them during inspections. Small businesses have less of a burden, but must still maintain them for 3 years. In addition, FDA may request a written list of all ingredients in the product's fragrances or flavors if it believes an ingredient or combination of ingredients has caused serious adverse events.
Good manufacturing practices, also known as GMP, will also be a requirement of facilities that manufacture and process cosmetic products that are distributed in the United States. Since MoCRA has only recently been enacted, FDA has not had the opportunity to create a cosmetic GMP as required under the new regulation. What we do know is that MoCRA will require FDA to establish good manufacturing practices that are intended to protect the public's health and ensure that a cosmetic product is not adulterated. These regulations will allow FDA to inspect facilities and review all records that it deems necessary to verify compliance with GMP as prescribed by FDA. MoCRA also includes provisions for a simplified, less stringent GMP for smaller businesses, which we will discuss later in the presentation. Products deemed adulterated if not manufactured consistent with GMP requirements. Cosmetic safety, substantiation, and record keeping will also be required. Companies must maintain records supporting adequate safety substantiation for their cosmetic products. As mentioned before, these tests, research, and data will show that a cosmetic product is considered safe and not injurious to users under the conditions on the label. FDA cannot consider a product unsafe solely because of minor or short-term reactions in some users. A product will also be deemed adulterated if this requirement is not met. We'll now go through mandatory recall authority, records access, and inspection. In regard to mandatory recall, if FDA determines there is a reasonable probability that a cosmetic is adulterated or misbranded and that the use or exposure to such cosmetic will cause serious adverse health consequences or death, the Secretary shall provide the responsible person with the opportunity to voluntarily cease distribution and recall such article. If the responsible person refuses to or does not voluntarily cease distribution or recall such cosmetic within the time and manner prescribed by the Secretary may require, as it deems necessary, such person to immediately cease distribution of such article. The Secretary shall provide the responsible person who is subject to an order of the recall with the opportunity for informal hearing to be held no later than 10 days after the issue of the order or whether adequate evidence exists to justify the order. The FDA also has authority to access records relating to a cosmetic product under certain circumstances. Record access does not include cosmetic formulas, recipes, administrative, or research data. FDA may request a list of ingredients in a product's fragrances or flavors as they have been contributed to a serious adverse event. All talc-containing cosmetics will be required to adhere to an established standardized testing method for detecting and identifying asbestos. Once established, companies will be required to use this testing method for all talc-related cosmetics. In regard to PFASs, FDA will use scientific evidence to assess the safety of their use in cosmetic products. This will also include any associated risks. Toxicological research can be included in this assessment. FDA will publish a report summarizing the results of this assessment conducted no later than 3 years after the enactment of this act. FDA will take into account small businesses and provide flexibility for simplified requirements or exemptions. FDA defines a small business as those with an average gross annual sales in the US for the previous 3-year period is less than $1 million. Small businesses that do not engage in the manufacturing or process of cosmetic products that we will discuss later can be exempt from certain regulations that include GMP, facility registration, product listing, and will only be required to maintain adverse event record keeping for 3 years. As mentioned, this does not apply to any cosmetics that come in contact with the eye, are injected, that are intended for internal use, or that alter the appearance for more than 24 hours under the conditions of use that are customary or usual. Those are the exemptions that apply that would not be considered a small business.
In light of these monumental changes being made to cosmetics regulation, you may find yourself wondering what is next and how am I going to prepare? Thankfully, FDA will be giving a staggered implementation schedule for all of these new requirements. On our next slide, we'll see how these all line up. We've created a timeline here to assist you in understanding how and when these new requirements will become mandatory. We'll first discuss the requirements that will be mandatory at the end of 2023. Cosmetic facility registration and product listing must be completed by December 29th, 2023, which is 1 year from the date of enactment of MoCRA. Also, companies will need to start reporting serious adverse events to FDA by the end of this year and maintain their product safety substantiation data. As we move into 2024, professional cosmetics must include the mandatory information described earlier in this presentation. Labeling must include the responsible person's contact for adverse event reporting as we move into 2025. FDA's mandate to establish and require standardized testing methods for detecting asbestos in talc ingredients intended for cosmetic products should result in a proposed rule by December 2023, with a final rule no later than 180 days after the proposed regulation method is finalized, so approximately June 2024. The fragrance allergen rule will be dependent on FDA establishing a list of allergens, which should be proposed by June 2024, with a final rule issued 180 days after the public comment period closes. It is likely that FDA will grant a compliance period to allow companies time to update their labeling. FDA will issue a proposed rule for GMP requirements by December 2024, with a final rule due by December 2025. Lastly, the report regarding PFAS in cosmetics is due to Congress by December 2025. With all these dates in mind, it is important for cosmetic firms to begin to plan how to meet the new requirements. The final section of our webinar will focus on how you can begin to implement changes and take action to ensure that you are in compliance in the years to come. One of the earliest requirements is the facility registration. If your firm manufactures or processes cosmetic products, start to gather this information now, as it will be required by the end of this year. At this point, FDA has not stated what system will be used for registration or when registration will open. You will want to be prepared the moment it becomes available. You will need basic company information, but also all brand names, product categories, and responsible persons for which you manufacture. For large contract manufacturers, this could take some time, so begin now. If you are a non-US firm, determine who will be your US agent. Registrar Corp has a service to assist in this requirement. We will also ensure that your registration is professionally done and kept up to date as required by law. Also bear in mind that you must notify FDA within 60 days of changes to the registration information, and FDA registrations are to be renewed every other year. If you fall under the definition of responsible person, you need to prepare the information necessary to list your products by the end of this year. You will need to obtain the facility registration numbers for your manufacturers, as well as contact information for your firm. Product names, categories, and ingredients will need to be declared in the listing. FDA will be allowing for flexible listings that may ease some of the burden. Flexible listings allow for a single submission for multiple products that have identical formulations or that differ only in color, flavor, or taste, or net quantity of contents. Your firm may save significant amounts of time by determining in advance which products might qualify for this process. Note that failure to submit your product listings could result in a mandatory recall, so get started now. In order to prepare for the adverse event reporting requirement, firms should determine for which products they are identified as the responsible person on the label, and identify an individual within their firm who will be responsible for the reporting process. As an alternative, you can work with an outside service provider in order to ensure that reports are being reviewed and proper reporting to FDA. This individual needs to be prepared to submit serious adverse event reports to FDA within 15 days of becoming aware of the event, provide new and material medical information related to the event for 1 year after initial submission, and submit fragrance or flavor ingredients that may have contributed to an event within 30 days of FDA's request. Make sure that your company establishes a standard operating procedure to make sure that this requirement is met. As part of your labeling preparation for MoCRA, you should determine if any of your cosmetics are marketed for professional use only, and ensure that they meet the existing labeling regulations for cosmetics, and include a statement that only licensed professionals may use the product. You need to complete this by the end of this year. Within the next 2 years, you must ensure that the adverse event reporting contact appears on your product labels. You should also begin to contact your suppliers now for information on fragrance allergens that may be present in your products. FDA will determine which allergens are to be declared in future rulemaking, but it is likely that they may include allergens that are required to be declared in other markets, like the EU. FDA's proposed list is due 18 months after the enactment of MoCRA. FDA's mandate includes consideration of international, state, and local requirements for allergen disclosures and threshold levels, including EU substance and formatting requirements.
As mentioned before, cosmetic safety substantiation reports and records will need to be maintained as early as the end of the year. It is important to designate an individual within your company that will be responsible for gathering and maintaining safety records. MoCRA specifies that adequate substantiation must be in the form of tests or studies, research, analysis, or other evidence or information that is considered among experts qualified by scientific training and experience to evaluate the safety of cosmetic products and their ingredients sufficient to support a reasonable certainty that a cosmetic product is safe. Start to gather your testing, research, and information on your cosmetic products, but do not only assess at the INCI level, but the complete raw material composition data and supporting documents, including residuals and traces. This will allow you to see anything that would be considered unsafe for your cosmetic product. As we wait for FDA to issue GMP proposed rule and the final rule, there are steps to take to help prepare your team for GMP. First steps are to determine the personnel in the facility that will be responsible for GMP compliance, maintaining SOPs, and handling audits. Start to educate this team by introducing them to existing FDA documents on GMP. As mentioned, FDA issued guidance for the industry on GMP, with the latest revision of this guidance in 2013, incorporating elements of ISO 22716. Though this is not the final law, it is a great place to start to understand the process. For those with little to no understanding of GMP, it would be wise to begin to take online training courses that give intro and beginning information on good manufacturing practices. Next, is it important to review your current SOPs and practices of your facility and evaluate any gaps in the process. This can include the lack of proper training, outdated cleaning procedures, improper storage, and overall layout of the facility. All of these factors focus on the requirements needed to protect public health and ensure that a cosmetic product is not adulterated. Now that we have outlined the regulation, given some tricks and tips of how to prepare in the coming months, we're going to answer some questions.
So I see a question. Do we know when it will be possible to register a cosmetic facility? Will the deadline for registration be extended beyond December 31st, 2023? So at this point in time, FDA has not published any sort of timeline as to when companies can expect the registration portal to open. Unfortunately, they haven't really provided much guidance in terms of what that portal will look like, where it will be placed, or really much anything about it. So we know, though, that a lot of industry organizations, including the Personal Care Products Council, have been in close contact with FDA to provide their input on what that registration portal should look like and other elements that should be incorporated into it. We also know that the deadline of December 29th, 2023 is still it's written into the law. However, FDA may be able to use enforcement discretion if it determines that it'll be necessary to extend it. We know they've done this in the past with food facility registrations, so they do have that power. The question will be whether or not they use it. So I think the next 3 or 4 months are going to be very telling as to whether or not FDA will be extending that deadline or not, and when we can begin that whole process when the portal becomes available.
I see a question about renewing the product listings. So the responsible person must renew the product listing annually with an update. What if there are no updates? Would the product listing require any renewal after a certain time period? So MoCRA does, state that they're going to do abbreviated renewals for both the facility and product listings. So product listings will be every year, while facility will be every 2 years. And what those abbreviated renewals will look like, we are still not sure, but we hope to see that if there are no updates, that it's easy to just reissue the product listing. In terms of the facility registration, same, we have to wait to see what the abbreviated renewal process will look like.
I see a question about working on SOPs for reporting adverse events and the 3500A MedWatch reporting form, and whether or not FDA will be using this. At this point in time, it's not really clear what the mechanisms for adverse event reporting will look like. FDA hasn't issued any guidance yet regarding this requirement, so we're eagerly anticipating that they will. Companies can submit comments actually to FDA and communicate with FDA regarding any concerns that you have. So I know a lot of industry organizations are doing this, but you individually can also submit comments to FDA, and you may want to consider doing that if there is a manner in which you think FDA should allow for the submission of these reports to the agency.
So I see a question, is the small business designation based on average sales over the past 3 years, 1 million per year, or is that 333,000 per year? So the FDA states those with an average gross annual sales for the previous 3-year period totaling less than 1 million. So it would be for those previous 3 years. Same question. If you are, oh, go ahead.
Sorry, go
ahead,
ahead. Sorry,
Anna.
go ahead, Jacqueline.
Lots of questions. If you are previously registered in the voluntary program and have a new product ready for market, can you still market now, or do you have to wait until MoCRA system is online? So everyone is still marketing their cosmetic products in the United States. Just be aware of the timing that surrounds for MoCRA to have whatever you need to be able to do that product listing when the portal does open. So it's not that, people have stopped sales for cosmetics in the United States, but just be ready for that December 29th date with all that information.
I see a question. If we use a subcontractor to manufacture cosmetic products, is it up to us, responsible person, or the subcontractor to register the manufacturing site? In this particular case, it should be the subcontractor, the actual manufacturer, that does the registration. There are a number of reasons for this, but by far one of the most important ones is that by registering, you are asserting that you are taking on the responsibilities required of a facility, so GMP compliance, etc. And so it really should be the manufacturer that completes this. You would not want to register a manufacturer, particularly without their knowledge or consent, in order to get your products listed. It really needs to be the manufacturer themselves. So you probably want to reach out to your manufacturers, make sure that they're aware of this because it will be part of your product listing. And you don't want to get kind of caught, with them not having registered while you're trying to do your product listings. So again, reach out to them now to make sure they understand this requirement.
And just to follow up on that, for anyone who is working with contract manufacturers and they're manufacturing on your behalf, make sure that you guys, sync up and realize who is registering, because there is only one registration required, even if that contract manufacturer is manufacturing or processing goods for multiple responsible persons. It's just it's important to know the FDA is only going to accept one registration for that facilities. So again, when the portal opens, we'll see what that looks like, but just to note that only one registration would be required.
Okay, I see another question. Can the responsible person be the UK manufacturer, or do they have to be in the USA? So this is a good question, and again, sort of underscores why it's important to understand all these definitions. So the responsible person in FDA speak may be a bit different than the way responsible person is used in the UK and the EU markets. For FDA, the responsible person is simply the manufacturer, packer, or distributor that's named on the label. And that can be a US entity or it can be an overseas entity. That's a simple baseline requirement. However, a US agent is required for the manufacturer as part of their registration process if you're not a US company. And there is the requirement of the domestic US address or phone number or an electronic contact, which can be a website that goes on the label. So the takeaway, though, is that you aren't required to actually name a US manufacturer, packer, or distributor on the label.
I see a good question here. We are a contract manufacturer located in the US, but with some facilities in the EU, Dominican Republic, Poland, and Korea. Can the US facility work as a US agent for the affiliate? So the US agent needs to be somebody who can have direct communication with FDA for all their international facilities. So if you are a US facility, and you want to designate yourself as that US agent, your facility then will be responsible for all of the communication that happens with FDA for anything that happens with those surrounding facilities. So it could be a large burden for the US facility to take on to communicate all of the requirements that are going to be needed, all the product listings. If there are any issues, there are any errors, that facility will take on that burden. So just be conscious of, the U.S. agent part of it and what the responsibilities mean under that, and if your facility has the ability to take that on as well. It's an important thing to consider that you'd basically be the one-stop shop for everybody that you are working with.
Okay, I see a question. We are a Canadian cosmetics company using Canadian subcontractors to manufacture our cosmetics. I assume we are the distributor if we sell our products to the US. Do we need to register the subcontractor manufacturers to FDA? So yes, your subcontracting manufacturing facilities would all need to complete the facility registration process. If you are the distributor that's named on the label, then you would be considered the responsible person and you would be in charge of the product listing portion of it. But you would not do the facility registration. And as I mentioned before, you really do want the manufacturers themselves to complete that registration process because they're agreeing to inspection, they're agreeing that they're meeting GMP requirements and all of the other requirements that are imposed on a facility under MoCRA.
If a company is already registered as a cosmetic facility, will they need to register under the new system once it is available? So yes, unfortunately, everyone who has registered as a cosmetic facility before MoCRA will have to register again under the new system. And this also is anyone who has done a voluntary cosmetic registration as well will have to re-register under the new system. From what we understood from the FDA webinar, Dr. Katz basically said that the old VCRP system was not robust enough to accommodate a mandatory product listing and mandatory cosmetic registration for facilities. So they had to build a new system in order to accommodate the influx of registrations and product listings. So they felt there was no need to migrate the information either because they wanted to start fresh. Because a lot of the data that was in old VCRP either was not updated, maybe expired, unlisted. So they thought it was best to start a new system, which is why you'll have to be registered again. See, another question, who is responsible for product registration, the contract manufacturer or the customer? So facility registration falls on the person that, the owner or operator that manufactures or processes the cosmetic product. So if the contract manufacturer is processing and manufacturing the cosmetic product, they would be responsible for facility registration. If the customer is the person that is listed on the label, they will be responsible for the product listing. You can be both. You can be the person that is manufacturing, processing a cosmetic product, and also the person that is listed on the label, which means then you'd be responsible for both.
Okay, I see a question. Is there any detail about how in vivo testing laboratories for claims substantiation are governed here? Is there a requirement to test at FDA-registered laboratories? Is there any discussion of claims as opposed to safety thus far? So MoCRA does not actually address anything about claim substantiation. It's limited solely to the topics that we've discussed today. And so the substantiation for claims still falls on the manufacturer and the person responsible for the labeling. What I will say, though, is to caution everyone to make sure that even if you've substantiated a claim, you also need to be aware that it still has to conform to what FDA considers appropriate for a cosmetic product. And because it's a common problem with labeling that companies make claims, even if they're substantiated, that the product affects the structure and function of the body, which actually exceeds what FDA considers appropriate for a cosmetic. FDA considers cosmetic claims to only be appropriate if they discuss altering the appearance in a very kind of superficial way, but not making any sort of temporary or permanent change to the structure or function of the body. I see a couple of hands up. If you wouldn't mind putting your questions in the Q&A button, that way then we can get to them that way. We're going to use the Q&A little kind of chat feature to go ahead and go through these questions. So please do put them in there if you can.
I see a question on GMP. Is the GMP standard the ISO 22716-2007 standard or something else yet to be defined? So when talking about GMP, so the ISO 22716-2007 standard is the European standard. So that is the requirement under GMP to sell a cosmetic in Europe. For FDA, they basically have taken the 22716-2007 standard and have updated it 2008 and again in 2013. So they've added some provisions to that GMP to make it a little bit more defined in their terms for cosmetic. There are still discussions that are happening right now about what standard they plan on taking and adapting for GMP for cosmetics for FDA. For those of you that do not know, June 1st, there is a FDA GMP listening session. You can sign up to listen to all the companies and facilities in the industry speak their concerns about picking a standard. From everything that we have been learning about GMP and where they are going to kind of look for. They say international standards. They want to make sure they're compliant and kind of aligned with other GMPs throughout the world. They don't want to put any additional burden or additional certification that's needed. It would really leave smaller companies not able to kind of conduct that business as well as larger multinationals. But yes, if you guys have, from 10 to 4 free on June 1st, definitely sign up and you can hear a little bit more about the industry and FDA's, responses to some of those comments.
I see a question in relation to the cosmetic facility registration and about the product category. Does this mean a generic product category, for example, face wash, face cream? What is the definition of product category? Thanks. This is kind of a big question because, and something that Jacqueline and I have been sort of, wringing our hands over because FDA has not actually said what the product categories are going to be as part of the product listing or the facility registration portal. We can hope that it will mimic the product categories that VCRP used, which were pretty comprehensive, covering most cosmetic products that are distributed. But it's unfortunately impossible to know at this point. So we're really hoping that FDA will clarify whether or not they'll just carry over those VCRP product categories or whether they'll be creating new ones as part of this new mandatory registration and product listing. I think a good thing to do for companies that are starting to prepare is to go ahead and use those VCRP product categories, since that's all we have right now. But do be aware that FDA could change their mind, and they could, create some different product categories. And so we'll all have to be able to adjust for that.
Yeah, and that being said, the product categories have not been updated in some time. So there is a big push from the industry to make sure that we're able to add product categories, all in lieu of innovation and all that blue sky thinking. They want to make sure that, every product category is answered, or that multiple product categories can be used to claim on a product as well. So it's going to be interesting to see what FDA chooses to do in terms of product categories. But as Anna said, get your list together, use that as a guide. The best thing to do is start realizing, which ones fall in what product categories and what information you're going to have available when the portal does open. If a contract manufacturer just fills bulk, would that be required to be on the label as a facility? So if a contract manufacturer fills a cosmetic fills a container with a cosmetic product, that technically under other FDA definitions would be processing. So you would be included in the facility registration portion of MoCRA. If that person is also on the label, then you would also be responsible for the product listing. What's really important about this question, and what's really important to point out, is that the FDA has kind of put a definition for what manufacturing and processing means. They kind of use them interchangeably in other parts and definitions, and basically that's manipulating the cosmetic product. The term processing has yet to be fully defined in MoCRA, but we like to use, for the time being, the idea that processing does mean any manipulation of the bulk as well. So that would be a cosmetic product being filled in a container, or cosmetic bulk filled into larger containers. Anything that would risk that product being cross-contaminated, anything that would risk that product being a public health concern. That's the best way to go and look about it if you're questionable if you need to register or not. MoCRA also very much outlines who does not have to, so labeling, relabeling, packers, repackers that are not filling, that do not have to register as a facility. So just keep that in mind if you have questions about that. If you are touching the physical cosmetic product, you most likely will have to register.
Okay, I see a question. If the responsible person can be a non-US based manufacturer and we add electronic contact information of it on the label, do we need to add any information of US agent on the label? What is the function for the US agent? Okay, great question. So if you are a manufacturer, also named on the label, then you are the responsible person too. If you add a website or electronic contact through which where you can receive a report of an adverse event, then you've met all of those requirements. And so your labeling is covered. The US agent, though, is specific to your function as a manufacturer and your facility registration. And a US agent needs to be named. They do not have to appear on the label, but they're part of the registration. And the rationale for this is, for foreign manufacturers, FDA wants someone who is physically located within the United States to serve as a contact, so that if the agency decides that they want to go inspect a facility, they contact the US agent. If they want to issue a recall, sometimes they contact the US agent. The idea behind it is so that there is somebody literally within the borders of the US that is responsible for making sure that FDA can contact that facility. And so that's the function of the US agent. So you do want to have somebody who is competent and someone who will take this responsibility seriously. We actually serve this function for about 20,000 food companies. We do it for drug and device companies as well, where we will make sure that any FDA contact or communication is received by our clients. You want to be very careful. Sometimes companies will use either a distributor or an importer, but because that person, you also have a business relationship with, or that person, may not appreciate if you then, go through other distributors, that can get a little tenuous. So we strongly recommend using a third party to serve as your US agent if you don't have your own US affiliate within the borders of the United States.
See a question here. We are a CM fill pack cosmetics facility. We are registered with FDA as an OTC fill packer. Do we still need to register with this even though we are still registered? We are registered as a drug fill pack that is held as a higher standard. So MoCRA does clarify the cosmetic drug requirements. So if you are a cosmetic contract manufacturer that only produces cosmetic OTCs, meaning you only do SPFs and acnes and don't do any cosmetic products, you follow the drug establishment registration. If you are a contract manufacturer that does drug or does OTC cosmetics or medical device cosmetics and plain cosmetics, there will be a requirement for you to register as a cosmetic facility. So really important to make that clarification of where your facility holds. And they're doing this on purpose so that, that the cosmetics are regulated under the cosmetic GMPs that MoCRA will place in effect. Drugs that are also OTC will also have other implications in terms of like fragrance allergens. They'll be having to list those as well. So MoCRA does make a really good clarification of what's going to be required. Just so everyone knows on this call, we're going to do some deep dives and mini MoCRA sessions in the coming months to go really in depth into registrations and listings and labelings where we outline all of those great facts for you that are hidden deep in the MoCRA regulation. But yeah, so there's going to be a lot of questions around OTC and cosmetic products, but just be aware that clarity does exist and they have outlined that. See, would a foreign facility need to register if they sell to an EU responsible person and does not directly sell in the US? So yes, so if you are a foreign facility and if you sell to an EU responsible person, basically who distributes that product in the US, you technically need to register. The way that the facility registration is written means that you manufacture or process cosmetic products that are distributed in the US, meaning not sold in the US. So if you make a product that even makes its way to Europe first and then to the US, you still have to register. And I see a couple questions. Yes, we'll be sending out the recording of this webinar as well as the slides. So you guys can come back and look at the slides and look at some of the information. And again, we'll be starting next month. We'll be doing mini sessions so that you guys can kind of jump in on your lunch breaks and or your morning's coffee and kind of listen to us talk through some of the deeper issues and conversations that are going to be coming up in the coming months. I see a lot of questions about safety substantiation and EU. So would the EU safety substantiation testing be efficient for FDA? So the FDA has cleverly made sure to not outline any specific testing. It doesn't say RIPTs or oculars. It does in MoCRA state that they about animal testing. It doesn't make it a law. It doesn't make it banning it. It clearly just states that they don't agree with animal testing. So it's really up to your company and how you view your safety and toxicological data. Again, the EU requires a lot of safety testing, the CPSR safety assessment. So that is a really good place to start to evaluate your safety of your cosmetic product, and be smart about what you're actually testing. If you have an eye product, right, make sure there's enough substantiated safety data for around the eye. If you have a face product, make sure there's enough substantiation around using it on the face. And same with anything that might require additional leave-ons or rinse-offs, evaluate it at that level, and be just ready to make sure that you can defend the reasoning behind why you consider that cosmetic safe, that you reviewed all the safety of the raw materials, of the residuals, of the traces, of its use, the daily exposure of that use. So yeah, so it's very difficult to say if they'll accept everything from the EU, because they have not outlined what tests that they really need. But if you have that data and you have the information to show that that cosmetic product with its intended use, with its intended daily exposure, yields little to no risk and is generally considered a safe, I feel that you should be in good standing. Will there be a cosmetic facility registration fee? So currently there'll be no registration fee for this year, like the OTC facility fees. But what that looks like um, moving forward is here to be seen.
Yeah, I believe that Congress would have to authorize FDA
Yeah.
to require fees, which is kind of what they did with all of the OTC monograph drugs. The CARES Act in 2020 is what granted FDA the authority to assess fees on companies that had the OTC monograph drugs. So we're likely to get some sort of a heads up, some advance warning from FDA and from Congress if it's part of their plan to go ahead and assess fees. For now, the food facility registration doesn't have any fees associated with it. Medical devices do, drugs sort of do, although not all companies will have to pay that. So that's kind of a wait and see. But for right now, it doesn't appear that there's going to be a fee charged with any of this.
So we were so in depth of answering questions. We are over our 10. We're over our hour time, but I hope you guys really enjoyed this webinar. Again, Registrar can help in several ways, and we will be having mini sessions coming up to help navigate through these. We like to call it the halfway mark, right? We're about to hit June. We have 6 months until everything really important is due. So we're really going to do deep sessions to try to get you guys to understand what's due, how to prepare, some clarities of definitions, things that might have missed in yourselves reading the regulations. So look out for those emails, look out for those mini sessions, and whatever we can do to help, please reach out. We're happy to guide you through this MoCRA regulation for cosmetics in the US.
Yes, thank you everyone for participating today. I think it's also worth mentioning that Registrar Corp, we have representation on some of the working committees and the working groups that are interacting with FDA to try and, help FDA understand industry's concerns. So, if you have concerns, you could reach out to us. We can pass those along, through these channels that we're participating in to try and get FDA to minimize the burden on industry as much as possible while still meeting all the requirements that MoCRA imposes on the cosmetics industry.
Okay, thank you, everyone. Enjoy the rest of your day.
Thank you. Take care.